A very good morning to you, Home Secretary.
Good
Thanks
morning.
for joining us. We were just reflecting a little bit before we came to you, but the big story of the day, of course, is this extraordinary comeback victory for the Liberal Party and Mark Carney. He presumably is a good friend of the UK and someone you'd welcome in a leadership position in Canada.
Well, he's obviously very well known to people across the UK government, across the UK, as a result of his previous role at the Bank of England. But our relationship with Canada is extremely important, a very close one, both around security, cooperation, trade, on so many other areas. So, of course, we look forward to working with the new Canadian government.
And you, perhaps, Rachel Reeves, Keir Starmer, know him personally?
Certainly, and Rachel Reeves has worked with him for over a long period of time and had many discussions with him as well.
Let's move on to what you're announcing today, which is to try and prevent foreign nationals who commit sex offences from claiming asylum here.
Yeah. So at the moment, people can end up still claiming asylum even when they have committed significant sex offences. And we had the case some years ago about Abdul Ezedi, who last year committed the most appalling crime that people will remember in Clapham, the acid attack that people will remember. And yet he had been granted asylum in 2020 by the courts, even though he had been put on the sex offender register for 10 years. I just think that's wrong. I think it's a disgrace that he was granted asylum in that case, and that's why we're now changing the law. So if someone is put on the sex offenders register, if they have committed a sex offence in that way, actually they should not be able to be granted asylum in this country.
So there's a couple of areas I'm just keen to clarify. The first is perhaps a simple one, which is this is for sexual offences they might have committed once they have arrived in this country. If they've been convicted of something in their original country, that's not relevant.
That can also apply. That can also be taken into account.
That can also apply. And so you'd recognise a foreign country's conviction in that regard?
We can also take that into account as part of the asylum system.
The other question that everyone is raising on this is the difference between what the courts can still interpret. You're obviously passing new legislation here. Will that supersede things like the Human Rights Act and the European Convention on Human Rights?
Well, we continue to comply with international law, but the whole point is that our laws and our frameworks are about how we interpret international law, how we interpret whether it be different parts of international law, and how we make sure that the courts are then making their decisions based on the UK law that Parliament has passed. So this is about a system we've had in place for some time, a rule which says if someone has committed a particularly serious crime where the sentence is more than 12 months, then they can be denied asylum in the UK. I don't think that goes far enough. I really don't think that goes far enough. And that's why we're adding sex offences to the law as part of the border security bill that is passing through Parliament at the moment, which also strengthens counter-terror powers, for example, for going after criminal smuggler gangs.
So I did want to just focus in on this then as it regards to the ECHR, because there was a case reported in February where a Zimbabwean paedophile was allowed to stay in Britain because a judge ruled it would breach his human rights under Article 3 of the ECHR because an openly gay man who'd been jailed for more than 5 years for child sexual offences, he was likely to face substantial hostility from the Zimbabwean authorities if he was sent back to Zimbabwe. Clearly, he was already convicted for a 5-year term sentence, so it's already above the 12 months in law today. So that's what I just want to clarify. The change you're making today, based on this example, wouldn't alter because the ECHR and Article 3 of it would still overrule the legislation you're passing?
So the first stage is to ensure that someone doesn't get the additional asylum protection. That means additional status and length of time that they're allowed to stay in the UK. So the first stage is to ensure that that is prevented. Then the issue is we then seek to deport people. There can be further obstacles to deportations, including in the courts, including also practical obstacles in terms of being able to get the returns agreements and arrangements in place as well. So there can be further obstacles, but we seek to challenge those obstacles, and we have already increased our returns. We've increased returns, for example, of foreign national offenders by more than 20% since the election as a result of the work that we're taking. So, of course, there will continue to be obstacles. But the point that we're doing is step by step, we're tackling and challenging some of these issues in order to make sure that the asylum system itself has rules that can be properly implemented and enforced and respected.
No, and lots of good steps and measures there. I don't know, and forgive me if I'm wrong on this, if that answered my question, though. Specifically, Article 3 of the European Convention on Human Rights would still apply.
We continue to abide by international law. And so we do think you have to abide by international law because, to be honest, if we don't abide by international law, and that includes on the Convention on Human Rights, then it's much harder to get things like returns agreements and so on in place. So we do continue to respect that, including issues around torture, issues around other serious issues in the international law. But one of the areas where we are looking at the way in which international law is being interpreted in the United Kingdom is around issues around family life, where we've had a series of decisions that have been made in the courts. People refer to it sometimes as being about Article 8 and being referred to in the courts. We are reviewing that because we do believe that the way in which it's being interpreted in the courts is an issue, and actually there is greater clarification we can provide through our law to address that.
But this example is not about family life. And just to come
yes,
back to...
I think that was about torture-related, or the Article 3, I think you were referring
but
to.
it was about someone who's a convicted paedophile, but because they were also openly gay, they weren't sent back to Zimbabwe, where they thought the courts felt, under the interpretation of Article 3 of ECHR, that they'd face substantial hostility from Zimbabwe authorities. I just want to come back to the overarching point, which is, in your press release today, in your first answer, or second answer today, which was to say that you don't think it's right for people who have committed sexual offences to stay here. If there is then a law or a way that British judges interpret international law that prevents you enforcing that, is that OK? Because this example, and I haven't heard you say your new legislation would overrule this, this example would happen again under your new legislation.
So we've had a series of cases, including the Ezedi case that I referred to, that have been happening year after year after year. That is why we're changing the law. And what this does...
But would the law change prevent
this
example?
What it does do is it prevents cases, any cases like this, from getting asylum protection. Asylum protection, the refugee status, that can last for many years. That can give people additional status in the UK to be able to live their lives in the UK. There are other cases where people have been denied refugee status, they've been denied that asylum protection, where we still have to then work very hard through different legal routes, through different kinds of diplomatic routes, in order to get people returned or to get them removed from the country. Of course, there are still obstacles, but the point about the approach that we're taking is, we've heard, I think, from the previous government, all you got was rhetoric. All you got was a sort of just claim, let's blame everybody else, let's make these grand claims. We're taking a different approach. It's a hard graft approach, which says step by step we'll look at the ways in which we can change the law, the ways in which we can increase returns, the way in which step by step we can start to actually make the system more effective, fairer, and also have these rules being respected and enforced.
I guess my final point on this, though, is this man, unless you tell me otherwise, would still be here. So what would you say to someone that's saying, you too, all we're getting is rhetoric?
Well, we're changing the law, which would apply, for example, in the Ezedi case. That was during a period where it would have been possible to return him to his home country, and therefore we are taking action in cases like that, because there are cases that I have seen where countries, including countries where we have returns arrangements with, where it is possible to return them, but currently they are not, we are not able to do so because they're being granted asylum. So we know that there are cases going through the system where it should be possible to return people, and currently we are not able to, who are getting asylum granted in this country even though they have committed sexual offences. I think that is wrong, and that is why we're changing the law.
OK, but it sounds like there will still be some examples where, even though it's wrong, the government still won't be able to prevent the ECHR.
We'll continue to pursue cases through the courts, as we do.
Very quick final question, because we're out of time. The power outage in Spain and Portugal, has that sent a shiver down your spine? Is there a fear that our infrastructure could be hit in some way, shape or form in a similar way?
We do have a continued approach to resilience, making sure that we have the resilience and also security issues. We've been looking as part of wider security reviews across the country at how we deal with both resilience and also different kinds of challenges and threats, some of which can be the traditional security challenges, some of which can be the kinds of resilience things that we're talking about in Spain and Portugal, and we obviously support them and the governments there in the work that they're doing.
Home Secretary, great to see you this morning. Thanks so much for joining us.
Thank you.